what is the right approach, or what is the attitude you need to have to become a good litigator. So the first most important is you need to be very observant, highly observant. And when I say highly observant, what do I mean by that? Um, what I mean by being observant is, where do you actually start? Where do you start your learning from? So once you have moved out of your college, what you normally what we do is we would join either a law firm, or we would join a litigator or a practicing advocate, right? So when we do that, what is important is we normally spend the initial hours, in initial days or years sometimes. Unfortunately, though, spending most of the time in drafting, or I call it copy pasting, and just changing the names and addresses, and probably creating a lot of drafts, and I call that as production work. Unfortunately, you spend very less hours where it matters the most, which is inside the courtroom. So what I suggest is, particularly those who have started on their own, so, or as independent practitioners, this is my key success, key to success, and that is, visit the courts more, whether you have work or not. It doesn't matter. Visit the courts, and try to understand what is the environment, what is the ambience there, what is the how does the overall environment evolve around the cases on a day-to-day basis. How does a judge deal with the advocates? How do the advocates present their cases? How do the ahmed, or the reader deal with the people who are approaching him, or the advocates who are approaching him, or the munshis who are approaching him, and the court crafts. So all of these need to be. So what is when I talk about the right approach, what I'm trying to tell you is, even once you are, you have 2 to 3 years or even 5 years of experience, this is a very important skill, or a very important approach that you need to have. For example, I do it very often. If I've taken up a matter and it is to, let's say, be presented before a particular court, I do try to visit that court a day or two prior, and actually understand how the judge reacts to various forms of presentation by different advocates, right? So you can see, when you're in the court, you would be able to see very junior lawyers coming, and or even paralegals or interns coming and seeking adjournments. So right from that word, I'm just trying to tell you the very basics. So right from those aspects, that how does a judge react to a particular statement made to him, So, and then how does a judge react to arguments? What is his demeanor? What is his conduct? What is his general body language? What is his? Does he look approachable, or does he look very conservative kind of? Does he have a very conservative approach or something? So all of these aspects are to be observed, and that helps me actually plan my strategy of how to present my case before that particular judge, or in that particular court. So it is very important to actually visit that court prior to presenting your own case. When you are particularly out of college, you're certainly not presenting cases, but then for you, I would say you need to spend more time in the courts, rather than spending times within the offices, or doing the back office work. But of course, yes, back office work is important, because that is where you actually pick up those drafting skills that I had spoken of right in the beginning. Now, having said that, when I'm saying you have to observe, you also have to observe, because what we are talking about is here is being the best litigator. Then what you also have to observe, or where you have to lock your focus, is how the lawyers or advocates who are coming to conduct their cases are presenting their cases. How do they, for example, how do they open up, or first of all, how do they approach the court? Then how do they actually open up? How do they introduce their case? How do they build up their case, or build up their arguments? So what I'm talking about is about the delivery part. So how do they deliver their arguments, and what is the demeanor that, with which they approach the court? How do they conclude their or close their arguments? All of these matter a lot. Nothing works, nothing works as ideally as we learn theoretically. It is very different when it comes to the practical considerations, or how your cases are dealt with in the court. So I leave that up to your personal experience, how so that you see and learn from it. But what I'm generally telling you is that you need to be observant as far as the demeanor is concerned, as far as the delivery is concerned. These are two key areas that you need to pick up from your seniors. So having said that, then what the second approach that you need to have? I spoke briefly about it, that you need to be understanding. So when I say understanding, I'm not really talking about the emotional part, but what I'm talking about is you need to spend time diligently trying to understand what your client actually wants. So when a client comes to you, he might come and be talking the world out to you. He might talk things from A to Z. But then the point is, you need to really understand very clearly. You need to listen to him, of course, first. Listen to him very patiently, and then understand clearly that, okay, what is it that he wants? Jot it down very clearly. So unless you write down, I'm assuring you that you won't be able to really, reach the point or understand the remedy very clearly. That what exactly is it that my client wants? So having said so, understanding your client is of paramount importance. So the second approach that I'm talking about is, after the observation thing, is that you need to be ready to understand the needs of your client. That is very important. And third, then once you have understood the the needs of your client, you necessarily don't need to opine then and there. That is one of the biggest mistakes that many of the advocates, my friends in my legal fraternity do. They are eager to jump on and come out and give some opinion or the other. What I would say is, this is the only profession where before your name there is a word that is prefixed to your name, and that is learned. Even when you're being addressed in the courts by the judge, in his order that is dictating, or the order that is pronounced, it is always written learned counsel so and so, right? So what I'm trying to tell you here is, before giving an opinion on a particular matter, please take your time, please do your research, please tell your client that I will come back to you. Let me understand all the facts that you have given me. Let me just analyze it a bit, and then I'll come back to you with the best advice that can be offered. So I call that a learned opinion. So let us come back to our clients with learned opinion. That is very important, so that we don't come out and give out any opinion that comes out within the short limited experience that we might be having. So it is always preferred to come out with a learned opinion, and that takes a little bit of research, quite some drill, and a little work that you need to do at the back end.